All right, everybody, buckle up because we're diving straight into another wild day inside the courtroom. I'm breaking down every move, every reaction, and every decision the judge makes so you can see exactly how justice plays out in real time. Let's get into it.
I am approaching to see if we can amend bond conditions for two cases, actually. One of them is off docket. Is that okay? Can we?
Yes, absolutely.
Okay,
Good morning,
I have the case
Sebastian.
number.
What is it?
It's 254-9067.
A Wonk.
Yes,
Okay.
he is here. He had the no contact with the complaining witness restriction and also the address. He lives at the home, he pays the bills. We've spoken with the complaining witness and they said they're okay with no threatening and harassing and allow him to go back home.
Yeah. Sorry,
What say you?
yes, Judge, I confirmed with the complainant, they want him back home and, we were just asked
My
that.
only issue is that he's a prior murder case.
Yes, Judge.
What happened
It
with
was
that?
so many years ago, Judge. But he has not had any issues since. I do understand the concern. I
I would typically be more concerned, I think, given the age of the murder as well as the fact that that is his primary residence. I think it might be fair to.
Come up, Wonk. Oh, it's not on document, you said, right?
No, he's not.
So all we're doing is taking off the residential restriction, correct? That's all we're doing? Or there's a no contact order now?
But they live together, so
Who is the complaining witness in this case?
his girlfriend's son.
Yeah, I mean, we can do,
Have you ripped to see whether the son wants to have contact?
yeah, that's the person that I.
How old is this kid?
He's,
47,
yeah,
Judge.
he was.
Okay, so he's not young. All right. So Mr. Wonk, they're asking me to amend your bond conditions to allow you to have contact. I will. I'll allow you to go back to this house, but you need to understand there are still conditions of no threatening or harassing behavior. And what you need to understand, what threatening and harassing doesn't matter what you think. I don't care what you think. It's what the other person perceives. So you need to be aware of this. I don't know what kind of relationship you have with the complaining witness, but if it's something where you're constantly butting heads, that could be problematic for you. All he has to do is just call and say, hey, man, he's at it again. You're the one that's going to go back. You understand? Okay, so just be careful. There are many vindictive people in this world. Know who your audience is at all times. So do you mind filing those? No threatening or harassing and no weapons. And then if you don't mind printing out the memo for me, I'll amend it then. Okay, Mr. Wonk, we're going to need you to sign bond conditions reflecting that you understand everything. Just take a seat. Once we have you sign it, at that point, you're free to go. Okay, thanks.
Judge.
Oh, yeah, it's 254-9067. Yeah, okay.
And then I have one other on docket, Hodges. He may not show. We reset him for today to amend the bond conditions, but he's on docket. I can give you the case number off if you need it.
Yeah, it's not on document. What's your cost number?
It is 253-2980.
Okay.
Oh, I guess it's.
So this is a failure to give information.
Yes, so at his arraignment setting back in October, you did a no driving, and then we also put a curfew on it. He has been on those conditions since. He's done a defensive driving course. He hasn't had any bond violations or anything within that
Okay,
time.
is he here?
Yes, sir. Did I take these already? It is 253.
Come up, Mr. Hodges.
Thank you. We're just asking to lift the no driving restriction and the curfew.
Does he have insurance as well? Do you have liability insurance in your name?
Car insurance?
In your name?
Yes, sir.
You do have car insurance in your name?
Yes, sir.
As long as you have a Texas driver license and liability insurance, but you have to have it in your name, right? At that point, I'm going to allow you to drive, but you need to understand that it's a privilege. It's not a right. So if I see you acting a fool in the car, I will take it away again, and I'm not going to play this game again with you. Do you understand? Okay. All right.
Thank you, Judge. And the curfew,
Does he have any other open cases elsewhere
he
too?
does in Galveston,
Yeah, over there.
a DWI. How However, I mean, he works, he's an electrician, he works 2 hours away. And so the curfew hasn't allowed him to work any overtime or any late nights.
How long do you want? What do you want?
Can we just take it off completely? I mean, he's been on it since October and he's shown that he can be consistent and that he wouldn't have any trouble. Looking at it now, I think he deserves a second chance.
Okay, we'll see. If you pick up a third case, I'm gonna absolutely lose it. Do you understand? Make good decisions. We're not asking for much. You endanger my public. I'm gonna go nuts on your bond. Do you understand? Okay, all right, we'll give you a chance.
Judge, we're removing the DPS completely, correct?
Correct. All right, Mr. Bonds. Hey,
Mr. Proctor, again on the docket
Okay.
for, he's got a
is he back there? Okay.
restricted bond on his terroristic threat, raise it to 7. Would you lower it to 5,000?
Yes.
Okay. And then,
So hold on a second.
conditions,
What's it now? It's at,
7,000.
so what I'll do is, 5,001.
Okay. And then conditions on the, DWI.
Just standard conditions that, I mean, does he have any other, do you know if he has any other DWIs?
No, I don't think so.
No, Your Honor.
Okay, so just no alcohol, no dope, no weapons, no contact with the complaining witness in the terroristic threat. Just standard bond conditions, but let him know. If he picks up a third case, all bets off. Right. And then, Mr. Pons, I just sent you an email.
Yeah.
So-
I was going to ask you, because I did a lot of work to not work that Monday, that Super Bowl Monday.
You want the next day?
Yes. Okay.
Absolutely.
I'll see you Tuesday then.
Yeah, for sure.
All right, man.
I'll let Victoria know. Yes.
How are you?
What's going on with you, man?
Here on Mr. Matthew Adolph, the state was just filing a nollie on that case.
Okay,
He's on his way back from,
I'll sign it. I mean, if they're dismissing it today, then there's no need to address anything. You know?
he's on his way back from the VPR. That's passed, so it's a moot point. So
right.
it should be in your queue.
Okay, I'll send it right now.
All right, thank you, Judge.
You got it.
Maybe excuse.
Yes, sir. Thanks. Hi, Sean, how are you, man? If you want a copy of the nollie, we can give it to you now. I'm signing it now. Okay. Hi, Sean.
I have one. It's the top of page 12, just trying to avoid using the name with it.
Okay. What do you want to do?
So we are working with felony right now, kind of going up the ladder at the DA's office about the possibility of a diversion for upstairs that will, I believe, work this one out. Chris went upstairs and talked.
You representing him upstairs?
Yeah, yes, sir. Here and
Yeah, we're co-counseled on both of them.
Okay, great.
We feel optimistic about it, but we just haven't gotten a full answer since there's been a change in administration and all that. So everybody.
So did he have a PTI in the first? Is that why?
This is the evading that he's charged with. I have my own serious doubts about, but I think in his interest, he's trying to seek a PTI that may result in a plea in this case. But we're trying to
So,
work out
but
the
it's, the
details.
problem is that it's old.
Yeah.
So how long do you want? I mean, we got to set a time. I got to give you a time limit, right? Just, it's 220 days now.
And can we go about 30 days? That
At
will,
that point, I don't care. I'm going to set you for trial though.
Okay.
Like you're out of time at that time. That you're at 250 days and that, it's just too much, right? So I will give that to you, but that's the last setting.
okay,
Okay? So do what you can to try to work it out as fast as you can, but that's it.
okay.
Discovery's complete, right?
No, we are missing the search warrant and search warrant affidavit.
And then I'm going to have a big problem with this. And then I'm going to set this for if you guys are missing something at 220 days, Alex, I'm going to have a big problem with this.
Judge, just let me confirm.
Okay.
Regardless, your cutoff day with this case is 250 days. So what I'm going to do is I'm going to set this, if you're truly lacking something, I'm setting this for discovery hearing. And if you don't get it within that time, that's it.
Yes, Judge, it appears we're still missing the warrant, so
That's
we'll reach out immediately. We can get it.
setting it for a 10-day discovery hearing.
Hey, discovery
If
hearing.
you don't have absolutely everything,
Yes,
it's
Judge.
not going to go well for you.
Yes, Judge.
It's unacceptable at 220 days, you're still missing a warrant.
At that 10-day hearing, will his appearance be required or will be waived?
You can be waived. It's not a big deal. So we're on top of page 12. They're still missing a discovery. So I'm setting it for a 10-day discovery hearing. What I would do is I would subpoena the officer to come to court.
Yes, Judge.
Deuces Tecum.
And we'll have them,
But
we'll find it your own.
so set it for 10 days. But the cutoff with this case, regardless, is 250 days. At that point, it's plea or trial. So, okay, guys. See you in 10 days.
Thank you.
Thank you.
Oh, and hey, Judge.
Hi, Marcus.
Mr. Gonzalez Hernandez.
Okay. You ready?
Call him up.
Please.
Do you have the cause number?
Yes, thank you.
Our friend, Mr. Martinez, has not made it up, so hopefully he'll come up tomorrow, Judge.
Say it again.
Our guy from yesterday.
Are you posting bond?
I don't think he's posted bond. No, I don't see an ISO, so I guess we'll see.
Really? No one's gonna post it for him? No one's gonna post it?
I don't know yet.
Por favor, conteste a voz alta.
Good morning, Mr.
Buenos
Gonzalez
días, señor
Hernandez.
González Hernández. Good morning.
Are charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. So you are facing up to a year in jail and or a $4,000 fine.
Multa de $4,000.
You guys have worked out an agreement. They're offering you 1 year in Harris County Jail.
Año en la cárcel
For that to be probated for 15 months.
de meses.
Is this a second or a
Es
first?
la segunda y
True
la primera.
first?
True first.
La primera.
As part of the agreement for you to successfully complete this, you must do a DWI education class.
Base de
You must do a victim impact panel.
tener un panel de
You must also do a TRAS. This is an evaluation to see what other conditions you may need.
condiciones
If
necesarias.
they assess other conditions, you must fulfill these conditions as well. Substance abuse treatment,
También eso incluye tratamiento,
no breath test refusal,
pero,
meaning that if you're pulled over while driving a car and an officer asks you to submit a breath sample, you must do it. No drugs, alcohol. You must have a guardian interlock and 30 hours
20
of
horas.
community service. Does he have a Texas driver license?
He does not.
Licencia de
You are
manejar.
not allowed to drive. I want you to understand, I take this absolutely serious and you will be signing a promise with me today as part of your probation that you're not going to drive.
Como parte de
There's
su
nothing worse that you can do in this life than doing two things. Three, picking up a new case, drinking alcohol, or driving. Those things will land you in custody faster than anything else.
rápido.
And if you're not in this country with permission, and you go back to jail, it may be your very well last time that you
Última vez.
are here. Do you understand?
Entiende. I do.
You're giving up the right to a trial, right
Derecho
to
a juicio.
compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible
Ciudadano.
immigration
Hay
consequences. You can
posibles
be deported,
consecuencias migratorias.
excluded from the country, denied naturalization under federal law. You give up the right to appeal.
Su
Once you
derecho a
plead guilty to this offense, it will go on your record. You will never be able to take it off.
sacarlo.
Do you understand?
Entiende.
You also need to understand that if you get pulled over in the future, you're in a car driving, an officer, the first thing they do is they look at your driving record.
Hace
If they see a prior DWI and they come up to your window and they smell alcohol or they smell something funky, it's not going to go well for you.
que va a ir bien.
And from now on, you are facing a minimum of 90 days in jail for any new cases that you pick up.
En caso nuevo que usted le dé.
Do you understand?
Entiende. I do.
All right. How do you plead to the offense? Guilty or not guilty?
Guilty.
I will find you guilty, send you to the agreement. Good luck to you, sir.
Buena suerte, señor.
Thank you, Judge.
The fee, the fee.
Wait, the thing, okay, is it?
So, hold on, Tony. I need you to tell him one more thing. I want you to understand
Para que
something.
usted entienda.
That DWI is extremely big business in Harris County and in Texas.
Grande.
There is a $3,500 surcharge that typically would apply to you
3,500
on these types of cases. I will waive it for you now because it is a first offense. On a second DWI offense, it is a $6,000 surcharge, and if you don't pay it,
Si no lo
you do a
paga,
ton of jail time.
estar en la
Do you
cárcel.
understand?
Tiempo. ¿Lo
So
entiende?
get a clue. If you want to
Entienda.
drink, don't get into a car.
Meta en un carro.
All
Thank you,
right.
Judge. Appreciate it.
Ready? Wait.
Your Honor, it's actually off docket and it's just for bond conditions. We were here last week on the Devontae Levi. You want to
Okay.
give number?
Yeah, sure.
254-8452. So you were going to bonds, we're doing a new one. You ordered bond conditions, but they were not entered. So we're back again.
So let's enter it now and we can have them sign it and that way we're.
Okay, well, there's no notice of the conditions. So if you could please order them again.
Remind me what happened again, Alex, please, if you don't mind.
One moment, pulling it up. Let's see it.
And I talked to Mackenzie, Gary. The judge wants a reminder.
Oh, it's 254. Fine. Yeah.
He's still in custody, right?
No, Your Honor, he's on bond.
Is he here?
Yes, Hodges, please.
So, come up, Mr. Levi. Or is it Levy or Levi?
Is it Levy or Levi? Levy, Your Honor.
Okay. Mackenzie, do you mind?
Yes, so on January 21st, 2025, an officer made contact with the complainant. The complainant stated the defendant, she knew him from a previous dating relationship. The complainant stated she ended her relationship after finding out she was 6 weeks pregnant and was paying the defendant's phone line until she turned it off on the 21st of 2025. And the defendant started sending her threatening messages on the 16th, 2025, stating that he was going to make somebody jump on you and knock your teeth out, and delusional hoes like you deserve to die. The complainant stated she went to turn off the defendant's phone line on the 18th, and the defendant is now using Wi-Fi to continuously threaten and harass, with the last message on the 21st of 2025. The complainant is in fear for her life, and the defendant was ID'd by his Tennessee driver's license.
Got it. Okay. So he's also on probation. Are you representing him on his probation case upstairs?
That was terminated, Your Honor. It was early terminated.
So he's not on probation now?
No,
So, Mr. Levi, or Levy, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you back in jail. Do you understand? You're not to have any contact with the complaining witness in this case, and you're not to be in possession of weapons as well. Did we do
there's a
MOA?
MOA. It has not been signed, Your Honor. It's in the system, but it was not signed.
Right, so I'm entering now what's called a mattress order for emergency protection that identifies Miss Beck as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If you violate this court order, the state can and will file a violation of protective order against you, and that is the capital murder of misdemeanors. You pick up a case like that, it's really going to go sideways quick. Stay away and control the temper, because if you become a danger to my community, I'm going to unleash on you. Do you understand? I don't care who you are. I don't care where you're from, but I'm going to protect my community at all costs. We will have you sign the order for protection. I'll have you meet with Fleisher for bond conditions, and after that, you guys are free to go.
Thank you, Your Honor. I appreciate it.
Yeah, let me give you a cost number. Ready? 254.
And that wraps up this hearing. If you're into real courtroom moments, smart legal breakdowns, and raw reactions, make sure you tap like and subscribe. I've got plenty more coming. Stay sharp, stay curious, and I'll see you in the next one.